Here's something that most Texas workers don't know. About one in every three employers in Texas choose not to have workers' compensation coverage. And employers are legally allowed to do that in Texas. In fact, we are the only state where they're allowed to do that. And here's what's counterintuitive. If your employer has chosen not to get workers' compensation insurance, you actually might have more rights under the law, not fewer. And that's because a non subscriber employer loses several key defenses that they normally have to defeat your claim. I'm Max the Axe, the gold standard in personal injury, and this is a part of the law that a lot of people have no idea about. However, it might be the most important thing you learn after a workplace injury. And the company that told you to just file an internal claim, they may have just given up their strongest legal protections without you knowing it. Texas is the only state where workers' comp is optional. In every other state in America, the employer is required to carry workers' compensation insurance coverage. Texas, however, stands alone. Under the Texas Labor Code, employers can choose whether or not they want to have workers' compensation insurance. The employers who opt in are called subscribers, and those who opt out are called non subscribers. This is a term that will come up later. When an employer subscribes to workers' compensation coverage, the injured employee is entitled to medical benefits as well as a fraction of their wages. In exchange, the employer is protected from most personal injury lawsuits against the employer. The worker essentially loses their right to sue their employer directly in civil court. That's the trade off. However, when the employer is a non subscriber, that trade off disappears. The worker is able to sue the employer directly, and most importantly, the employer loses many of the key legal defenses that are often used to defeat a personal injury claim. And here's what a lot of people miss. Some of the largest employers in Texas, including many major retailers, restaurants, and industrial companies, are non subscribers. Oftentimes, workers assume that they have workers' compensation coverage because most states require it. But in Texas, that assumption is wrong and the consequences are significant. And you can actually look this up online for yourself. At the Texas Department of Insurance Workers' Compensation Registry, you can search for your employer to see if they are considered a subscriber or a non subscriber. What defenses a non subscriber loses. So here is where the law tilts in the worker's favor significantly. Under Texas Civil Practice and Remedies Code 406.033, a non subscriber employer is not allowed to raise three key defenses that they would normally have to defeat a personal injury claim. First, contributory negligence is completely off the table. The employer cannot argue that you were partly at fault for your injuries. In a normal personal injury case, the comparative fault, or the amount of fault that's attributed to you, would discount the total amount of damages that you could be awarded or that you would settle for. Against a non subscriber, however, this defense does not exist. As long as they were at least 1% responsible for the injury, they have to pay the full amount in damages. The next defense that is gone is called the fellow servant rule. Oftentimes, employers argue that your coworker is the one who caused the accident, and therefore the employer should not be held liable at all. In a normal personal injury subscriber case, another worker's negligence may block your ability to recover. However, against a non subscriber, that defense vanishes. And finally, the assumption of risk argument is completely gone. The employer is not allowed to argue that you knew the job was dangerous and you accepted the risk when you decided to do the job. This kind of defense is the ones that construction companies and oil field contractors rely on the most. But against a non subscriber, that defense is unavailable. And so here's the trap for the employer. If they can't make these defenses, the only defense they can make is that they were not negligent at all. In other words, they have to prove that they are 0% to blame and that they did nothing wrong at all. And in most workplace injury claims, some amount of negligence usually exists, whether that's in the training, the supervision, or the equipment maintenance, or just the safety enforcement of their own policies. And this is why non subscriber cases settle for far more than the average workers' comp case. And that's because the employer's legal exposure is dramatically higher. So here's the most important thing to understand. The loss of these three defenses makes a case like this, a non-subscriber case, so fundamentally different from a workers' compensation case. How to find out if your employer is a non-subscriber. You have the right to know if your employer is a non-subscriber, and all of the information is publicly available. The Texas Department of Insurance Workers' Compensation Registry keeps a running list of which employers have workers' compensation insurance and which are considered non-subscribers. Your attorney can look up this information usually within minutes. But there's also a faster indicator. If your employer has something called Occupational Injury Benefit Plan or Work Injury Benefit Plan, that's usually a sign that they are a non-subscriber. These internal plans are created by the employer, administered by the employer, and often designed to pay much less than what a civil lawsuit would recover. And this kind of insurance policy is completely different than the state regulated workers' compensation policy. But here's what the employer doesn't tell you. Many of these policies, the non-subscriber benefit plans that we talked about earlier, they require you to report the injury often within 24 hours of it happening. Now, each policy is different. It might be a much larger window than that, but you have to pay attention to the terms. If you miss one of these deadlines, it could eliminate your claim entirely. Remember, your employer created the plan, so they are the ones who set the rules. But here's the most critical point. Even if you do plan to use that kind of internal benefit plan, whether it's a work injury plan or whatever it's called, that does not stop you from also filing a civil lawsuit against your employer. You can do both. The internal plan may cover you in some of these damage categories, maybe some medical expenses, maybe some lost wages. However, the civil lawsuit is where you're going to get the full amount of damages. That includes pain and suffering, physical impairment, and mental anguish. So here's what you need to know. You need to verify your employer's workers' compensation status at the Texas Department of Insurance Workers' Compensation Registry before accepting any internal benefit plan. What damages can you recover against a non-subscriber? Workers' compensation benefits are limited by design. They may cover some medical bills and they may pay you a fraction of your normal wages. They don't cover pain and suffering. They don't cover physical impairment. They don't cover mental anguish. They don't even cover your future earning capacity. And often they cap you at the total amount that they can give you. A civil lawsuit, however, has no cap on the damages that you can recover. You can pursue the full range of compensatory benefits allowed under Texas law. And that means not just past medical care, but future medical care as well, the plan for the rest of your life because of your injuries. And not just a fraction of your lost wages, but your future earning capacity, if your ability to work has been affected by your injuries. And not just the full economic impact, but the non-economic damages as well. Money for pain and suffering, physical impairment, and mental anguish. And for cases involving gross negligence, in other words, where the employer knew about the serious risk of injury but continued to do it anyway, then you have the ability to go after punitive damages or what's called in Texas exemplary damages. These kind of damages are designed to punish the employer and deter future similar conduct. Here's what this means in practice. A normal workers' comp claim for a serious back injury may pay between $50,000 and $70,000 over the period of a few years. However, for a normal civil lawsuit, a direct action against the employer in a personal injury lawsuit, that will pay likely several times more. We're talking hundreds of thousands of dollars or even millions for the right case. This is often because you're able to find a lot more devastating evidence for the employer. We're talking about negligent hiring, negligent supervisions, skipped inspections, and unsafe working conditions that caused or contributed to the accident. And the employer knows that in a direct action personal injury lawsuit, that a jury of your peers is going to be assessing the pain and suffering and the physical impairment, and they're likely to take it extremely seriously when they see evidence of employer misconduct. So here's the most important thing to understand, that when you have a non-subscriber case against your employer, it unlocks areas of damage categories that were previously unavailable to you in a normal workers' comp case. Why the employer doesn't want you to know this. Non-subscriber employers benefit from one thing over all others: the worker's ignorance about the law. If you don't know that your employer opted out of workers' compensation, you may end up just filing an internal claim with the company. They may pay you a fraction of your wages or cover your past medical bills, but you'll have no idea what the case is actually worth. And in the meantime, your employer will get to avoid a very serious lawsuit that they will have almost no defenses against. So here's their tactic. When you get injured on the job, you may go to HR, you'll sign some paperwork and fill out some documents. They may send you to the company doctor. They'll put you into their system. And the whole goal is to keep you within their system so you don't look outside to talk to an attorney about your real rights. The entire process is designed to keep you in the company's system and away from the courtroom. Many of the company's internal plans contain clauses for arbitration or internal dispute resolution that may affect your ability to file a claim. However, under Texas law, some of these clauses may not be enforceable. What matters is if you can show if you were given meaningful notice or choice about these particular parts of the contract. Ultimately, the employer made a business decision about opting out of workers' compensation. They decided that the workers' compensation premiums was too much and they'd rather just pay out their claims individually. This kind of calculation only works if the workers don't ever talk to attorneys about their actual legal rights. Don't let their math work at your expense. So here's the most important thing to understand. Always talk to an attorney before accepting anything from your employer's internal injury plan. If you were hurt at work in Texas, call my office before you file anything. Do it before you sign anything, before you accept anything from your employer's internal benefits plan. You may have more rights than you think, and those rights will be significantly more than whatever the company is offering. And be sure to watch my video on Texas oil field accidents to see how those non-subscriber cases apply to the oil and gas industry. I'm Max the Axe for Lone Star Injury Attorneys. We fight for injured Texans.